Good morning, everyone. I want to welcome you to the ACLU's annual Supreme Court breakfast. Steve Shapiro, our legal director, will give you a little bit of an assessment of where the court has come so far and what we might expect in the coming term. And now I'll hand the program over to Steve.
My three colleagues who are with me this morning are all going to talk about ACLU cases in the pipeline that I think have a serious possibility of reaching the court this year, and if any or all of them reach the court, the year will start to look very differently, at least to those of us at the ACLU. John Hafetz is going to be talking about the El Mari case, which raises the critically important question about who may properly be designated as an enemy combatant and held in military detention and who has to be tried within the criminal courts of the United States. Mr. El Mari is the only person now being held as an enemy combatant within the United States. He's being held in South Carolina, and he was, as John will explain, arrested and detained in Illinois, was on his way to a criminal trial when the government chose to redesignate him as an enemy combatant. We hope the Supreme Court will take it. I think the Supreme Court should take it, and I think there's a reasonable chance that the Supreme Court will take it.
The import of this question, I think, is really self-evident. If someone like El Mari can be detained as an enemy combatant, though the allegations against him are severe, there's really no limit to who can be subjected to indefinite military detention within the United States. The case is effectively a crossing of what I would call a constitutional Rubicon. Once you've allowed the executive to detain people indefinitely because he labels them suspected enemies affiliated with terrorist organizations, perhaps plotting terrorist acts, there's really no limiting principle. And the whole tradition of civilian supremacy and the principle of the right to criminal process for those accused of wrongdoing is swallowed up by the specter of military detention power.
That's a different question than what you do with people who are carrying rifles and shooting at the U.S. forces on an active battlefield. We have never had a system of criminal preventive detention in this country, and I don't think that this is the occasion to begin. Chris Hansen is going to talk about the ACLU's ongoing, now nearly decade-long challenge to the Child Online Protection Act, which is probably heading to the Supreme Court, we assume, for its third time.
I'm here to talk about the Child Online Protection Act. It is a statute passed by Congress 10 years ago which makes it a crime to engage in speech on the internet if that speech is harmful to minors. It's fairly routine First Amendment law that the First Amendment prohibits content-based discrimination against speech, prohibits the criminalization of speech, particularly if there are less restrictive or more narrowly tailored alternatives available. And the fight has been primarily, and was primarily, at the trial court over internet content filtering. The internet content software filtering is very effective. The government spent $1 million on this study. The study concluded that almost all of the internet content filtering is over 95% effective and often as high as 98% effective in blocking sexually explicit speech to minors if the parent has installed it and if the parent has turned it on. Then there was evidence about the effectiveness of COPA as an alternative. And here are a number of ways in which filtering software is substantially more effective than COPA would be. The most obvious example is that COPA does not reach overseas speech. Nobody really thinks we can prosecute a website in Bulgaria that has sexually explicit speech on it. And therefore, COPA will only affect those websites that are domestically hosted. Now, by contrast, filtering software does in fact get overseas websites just as easily as it gets domestic websites. And filtering software also reaches all of those other protocols. Filtering software can be used to block video and audio and news groups and email and anything else that can be transmitted over the internet. And remember, what we're talking about here is harmful to minor speech. We're not talking about obscenity and we're not talking about child pornography. Obscenity and child pornography are illegal on the internet. They're illegal regardless of COPA, even if COPA it never goes into effect. Obscenity and child pornography will continue to be illegal. We kept saying to the government, what is it exactly that's harmful to minors but not obscene? What is it that is prurient to a 16-year-old and not prurient to a 17-year-old? The government ultimately said they couldn't identify a single website that fit into that category. So we gave some sample photographs to the government and we said, is this harmful to minors or isn't it? Tell us, we want to understand what this concept means. And my favorite irrationality in the government's response was a web page, a Playboy web page that showed a woman with her breasts naked, they said was not harmful to minors. A Penthouse page that showed a woman naked with her breasts bared, they said was harmful to minors. And then there was a third web page from a less well-known website in which the woman was naked from the waist up with her breasts bared, but there were stars that had been superimposed so that you couldn't see her nipples. They said that was harmful to minors. Now, in my mind, this is as irrational as the FCC trying to define indecency. It proves that the definition of harmful to minors can't be adequately applied, and I think that's another reason why COPA is unconstitutional. Supreme Court has not, the cert petitions have not yet been filed in COPA, although as Steve indicated, we expect them to be filed, and we expect the Supreme Court may well take the case for a third time.
Lachlan is going to talk about a case that is now on appeal to the United States Supreme Court challenging the constitutionality of the extension of the Voting Rights Act.
A municipal utility district in Austin, Texas filed a lawsuit, raised two claims. One was that it was entitled to bail out from Section 5 coverage, and the second was that if it was not so entitled, then Section 5 was now unconstitutional. What struck me again was the recurrence of the phrase gamesmanship. That really is the essence of their argument, that the only rationale and justification for Section 5 was to prevent jurisdictions that had demonstrated gamesmanship in trying to deprive protected minorities of the equal right to vote. And they said that the municipal utility district hadn't indulged in that kind of gamesmanship. Therefore, Section 5 was no longer constitutional. They make a lot of other arguments. And they say that Section 5, even though it might have been justified back in 1965, today it's no longer congruent and proportional because there's no significant evidence that there's a continuing need for it. I think that those arguments are without merit. And I ask myself the question, what is the court likely to do if it agrees to hear the Mudd challenge on the merits? And I'm inclined to think that if the court agrees to resolve the case based on the motions that have been filed, it will uphold the constitutionality of Section 5.